So unless you've been living under a rock, I'm sure you've heard all about how the SEC took a big fat L, a major loss in its fight against cryptocurrencies, specifically as it relates to its case against Ripple and its native token XRP. You've heard how the court sided with crypto in that cryptocurrencies are not securities. I mean, it's all over the news. Ripple ruling deals a blow to SEC's efforts to regulate crypto, says the Wall Street Journal. Ripple notches landmark win in SEC case over XRP, Reuters. Huge win for Ripple in SEC case, CNBC News. But is this really true? Did the SEC really lose its case against Ripple? And does it really have the implications to the broader crypto market as the media makes it out to seem? The answer is a resounding no, and I'm somewhat surprised to see how the media is reacting to this decision. As an SEC attorney, I'm obviously interested in these types of cases, and so I took a deep dive into the judge's ruling, and here are my 3 observations into what the judge actually said. And make sure you stay until the end of the video where I'll give you my thoughts into what comes next. But first, let's remember that Ripple is an actual real company, and it's actually doing some really cool stuff. It facilitates international transactions, very similar to what Western Union does, where people can send money from one country to another, but the difference is it can do it really cheap and really fast. You know, Western Union charges something like 10 or 11% per transaction, but with this crypto technology, you can actually transfer money for like $1 for every $1,000 you send, and it takes minutes instead of hours, if not days. And so Ripple uses its native XRP token to facilitate these transactions. So here's my first observation. So the main issue in this case is whether XRP is a security, and the same definition of a security applies here than it does with real estate investors, which we've talked about several times on this channel. The question is, anytime you take money from passive investors, where the returns are generated by your efforts, meaning the passive investor just gives you money, expects you to do all the work, and that generates the return, then you are issuing securities. And it's been my belief from the beginning that that's exactly what Ripple was doing. Ripple was creating this token, sending it to investors. The investors bought it with an expectation of a return due to the efforts of Ripple, and therefore this should have been a security, and that's been the position of the SEC from day one. Which brings us into observation number 2, which is the judge, in trying to determine whether XRP was a security or not, actually broke down these transactions to 3 categories. So the first category was institutional sales, which accounted for about half of the sales that Ripple made of its XRP tokens. And in that case, it's your standard definition of a security. They sold XRP directly to sophisticated investors, hedge funds, venture capital funds, provided them with some documentation, usually a white paper, but basically it was a contractual arrangement where they sold them XRP tokens, and the institutional investor had an expectation of a return and had that expectation that return would be generated by the efforts of Ripple. And so in that case, which is what I've been saying from day one, the court said, hey, this is clearly a security, and so you must comply with the securities laws, meaning you should either register your token with the SEC or you must find an exemption or it's illegal. So with the institutional sales, that makes sense. It's a security. Number 2 was the programmable sales, which were the sales that actually happened on exchanges. So when you and I went and bought XRP, the argument goes that we didn't really know whether we were buying it from Ripple or we were just buying it from the next guy or gal down the street. There were kind of blind bid-ask situations. And so the judge in that scenario determined that these were not securities because it believed that the person buying the tokens on the exchanges didn't reasonably expect the profits generated from XRP to be coming from Ripple. They were too far removed from Ripple. And therefore, the judge decided that in those scenarios, when it was sold to the public at large through exchanges, that was not a security. And then the third situation was simply, look, they were making payments to their employees and they were giving them the equivalent of stock options. They were giving these XRP tokens, and sometimes they would actually pay for services through XRP. And so I think in that case, it's clearly not a security because there was no investment of money, there was no anticipation of a return. And so this third category, I think, is pretty clear. And observation number 3 is that this does seem to temporarily help the exchanges like Coinbase and Gemini, meaning they're going to be able to have these tokens on their platform. And because they're not considered securities at this point, they should feel pretty comfortable that they're able to allow those tokens to not only XRP, but other tokens to be on their exchanges, which is no surprise that both Coinbase and Gemini and other exchanges have already come out to say that they plan to reinstate XRP into their exchanges and allow them to be traded. And honestly, will probably allow any other cryptocurrency that they currently feel a little uncomfortable with, the current ruling actually does seem to indicate that they are going to be safe, meaning the exchanges. But I'm really surprised with the judge's decision on the programmable sales because, let's be honest, when people buy and sell tokens on any exchange or any token, they're buying it with an expectation that the token's going to go up. And moreover, they have an expectation that that's going to be done by whatever company's issuing it. And so the judge's creation of these different categories, whether institutional versus the general public, first of all, it's not grounded in any SEC law that I know of. And it actually goes against what the SEC regulations are meant to protect. They're supposed to protect the individual mom and pop, the general public who aren't as sophisticated as the institutional investors. And what this judge is essentially saying is like, hey, if you're an institutional investor, then it's going to be considered a security. And so you've got to get all the protections necessary for the institutional investor. So the big boys and girls get the protection. But when it comes to the general public and when you're trading these things or buying and selling these things on exchanges, then, well, that's not something that they need protection with. Now, I'm not a big fan of regulation to begin with, but if you're going to have regulation, then you probably want to have the regulations apply to the people it's meant to protect, which is the general public at large. I do believe that the SEC is going to appeal this. There's no doubt in my mind. In fact, I'm really surprised that the SEC hasn't already come out with some kind of a media statement saying they are going to appeal this. Remember, this is simply a judge in the Southern District of New York. And so this will get appealed into what's the second district. These are all federal courts. So this is going to be the second district where that appeal will happen. And again, no other court in different parts of the country, if there's a case that's brought in California or a case that's brought in Texas, they aren't bound by the decision of the judge in New York. They aren't even bound by the decision of the Second Circuit if this actually does get upheld at the Second Circuit. So I do believe this will continue to make its way up the system. Maybe it eventually gets to the Supreme Court. So we are far from over in getting clarity as to whether these tokens are in fact securities. I do believe this legal battle will continue for years to come. And if you're interested in this topic, drop a comment and I'll make sure that I provide updates moving forward on what's going on with Ripple and the SEC's enforcement actions against cryptocurrencies in general.